Hi there, John Caddy here. I'm a Medicare compliance attorney from Charlotte, North Carolina, and it's my pleasure to contribute content to this trial lawyer protection packet, which you've recently purchased. Specifically, my portion here is regarding the Medicare compliance form, specifically to help address and educate your clients about future Medicare benefits as part of settling their case. If you think about it, trial lawyers wear a lot of hats, right? Sometimes you're an advocate, sometimes you're a fighter, sometimes you are a consoler, and sometimes you're a protector. And in fact, you're probably all four at the same time, depending on what part of the case that you're on. When it comes to being a protector, do you think that role extends to protecting your client's future health care coverage post-settlement? I think that it does. And in fact, if you think about it, you already do that when it comes to your client's potential future Medicaid benefits, right? If someone is a client of yours and they are enrolled in state Medicaid, you know that as part of settling their case, their future Medicaid eligibility could be threatened by receiving settlement proceeds. You have conversations and you ask questions of the client early on in the case. As part of moving forward and settling your case, do you want to protect your future Medicaid benefits post-settlement? And if the answer to that question is yes, then you start to investigate potential solutions, such as funding a special needs trust, or funding an ABLE account, or coming up with a spend-down strategy so that your client's future Medicaid benefits are going to be preserved and protected. If the client answers no, I don't want to protect my future Medicaid benefits, then you document that in the file accordingly, correct? Well, if you think about it, the exact same thing should be happening when it comes to protecting our client's future Medicare benefits, because that does not happen automatically, okay? We should be asking our clients before settlement and before even mediation, do you want to protect your future Medicare benefits as part of settling your case, yes or no? And if the answer to that question from the client is yes, then you investigate options with respect to protecting those future Medicare benefits. And there's a lot of options out there today. But if the answer from the client is no, I don't want to protect my future Medicare eligibility or benefits, then you want to properly document that within the file on a go-forward basis. And that's exactly what this form accomplishes. This is a very simple bullet point form that allows you to have a conversation with your client and educate them about potential options to protect their future Medicare coverage post-settlement. And should they not want to investigate those options, then advising them of the ramifications and repercussions of the failure to protect their future Medicare eligibility and benefits. At the end of that form, the client will sign, it'll be notarized, and then it will exist in your file for them going forward. Because here's what's going to happen in this new environment of Medicare set-aside regulations and Medicare more aggressively on an annual basis, preserving and protecting and recovering future medicals from certain individuals. We're going to see these issues more and more. We're going to see more issues of clients ignoring this issue at time of settlement and seeking medical treatment, and Medicare either denying the bills for that treatment or paying those bills and seeking reimbursement from the former client at a later date. And some of us are going to be getting phone calls from these former clients saying, hey, you never told me when we settled this case that I could lose my Medicare benefits, or that Medicare would pay bills but then come looking for repayment from me for those bills. And because of this disclosure form, you're going to be in the position to say, yes, we did talk about that as part of settling your case and dispersing proceeds to you. In fact, here's the form that we reviewed, and here's your signature at the bottom of that form. you were fully aware of this possibility. This Medicare disclosure form is going to be your best evidence if that former client decides to sue you or your firm for legal malpractice, or picks up the phone and calls the state bar to report potential ethics violations, such as competence, diligence, client communication, or safekeeping client property. It's my pleasure to contribute my thoughts and content to this Trial Lawyers Protection Packet. I hope you find the contents helpful. I feel certain that you're going to think that these forms pay for themselves on the very first case that you use them for, and will continue to reap benefits on a go-forward basis. Again, my name is John Caddy. Until next time.